Sit down. I want to tell you a little story about Vega and Tekoth. Unless you've been hiding under a rock lately, you know the Supreme Court's been handing down some big decisions. Decisions that'll affect jurisprudence in this nation for decades to come. They handed down a lot of cases, just not the two big ones we all hear about, which is Bruen and the Roe versus Wade case. They handed down a bunch of other cases, and I found one that may have slipped under your radar, as I'm probably sure it slipped under your radar. It centers around a criminal procedure issue called Miranda. But more importantly, it highlights a point I am always trying to make. And that point is, do not ever talk to the police if you're the subject or you think you're the subject of a criminal investigation. And a big pro tip on that issue is, if your conversation with a police officer starts off with, you have the right to remain silent, that is your cue to shut your mouth and request an attorney. And you have to expressly request that attorney. You have to say, I want an attorney. Although you have the right to remain silent, a lot of people do not have the ability. You must capture the ability to remain silent and adhere to your right. So let me tell you about Vega and Tekoth. Back in 2014, Vega was a Los Angeles County Sheriff's deputy. He responded to a call at a medical center in Los Angeles where a certified nursing assistant, Tekoth, was accused by a female patient of sexual assault. Now, I don't know if Vega was just a first responding officer or if he was a follow-up sexual crimes officer. So Vega gets there and he questions Tekoth in the hospital where Tekoth works. Tekoth provides him a statement that basically he confesses to touching this person and apologizes for improperly touching her genitals. There's a dispute between the party whether Vega was using coercive investigative techniques or not, but what is undisputed is Miranda was never read to Tekoth. Tekoth says Vega didn't read a Miranda. Vega says, yeah, I didn't read a Miranda. So there is no Miranda warning in this particular case. And it centers around, Miranda centers around custodial interrogation. When you're in custody and they're interrogating you, the police are interrogating you, any police, state police, county police, city police, federal police, ATF, FBI, anybody. When any law enforcement agent interrogates you and you're in custody about a crime, they're required to read you Miranda. So what happens if they don't? Well, this case sheds a little bit of light on that. The case goes to trial in the district court. The first trial ends in a mistrial. During that case, Tekoth's lawyer filed a motion to exclude the statement. Ended in a mistrial, didn't matter anyway. Second trial, he refiles the motion to exclude the statement. The judge lets the statement in. He was acquitted. Second trial, he was acquitted, even if the statement comes in. So then Tekoth turns around and sues Vega for a 1983 violation, violating his civil rights. He claims because he didn't read a Miranda, he violated his Fifth Amendment rights against self-incrimination, and Tekoth was seeking monetary damages for a civil rights violation. The first trial, they sided with Vega. Tekoth appealed. It went to the 9th DCA. 9th DCA says, yeah, you have a case for a 1983 action, a civil rights violation. The Supreme Court reviews the case and says, no, doesn't happen that way. Violation of Miranda does not give rise to a cause of action for civil rights, for a civil rights violation. Basically saying that Miranda is a prophylactic procedure to protect your Fifth Amendment right. It is not a constitutional right in itself. So what does this mean? If you look back on all the cases that the different courts have interpreted Miranda and applied Miranda and issued opinions and decisions on Miranda, it centers around one thing. It centers around a defendant's statement. There has never been a Miranda case where the defendant was not making some kind of statement. And nowadays, everybody has a phone. All the officers have body cameras. So when they walk up to you, what you're saying to them can be a statement. And if you're in custody for that purposes of that statement, and you waive your Miranda rights, whatever you say can be used against you in court. If you are not in custody, let's say the officer comes up to you, and I've seen this happen when I was a policeman. Let's say something happens. Say you have to defend yourself. Somebody tries to break in your home and you have to defend yourself, and the person was unfortunately killed or gravely injured. I've seen it where the officers respond to the scene. The first thing officers want to do when they respond to any scene like that is secure the scene. I've seen officers respond to the scene, and I've done this myself. You respond to the scene, you go up to the person's obviously visibly shaken, and you go, "Hey, are you all right?" And then they'll start spilling their guts. Or you'll say, "Hey, what happened here?" Or they'll just start spilling their guts. Basically, it's that first interaction, and they're under such stress. When you open the door, when the officer opens the door for them to say something, they'll just start talking and not stop. And the police are trained to let you keep talking. So you got to be very careful. No Miranda case has ever arisen, no Miranda issue has ever arisen without a statement. So if there's no statement and you don't make a statement to the police, then you don't ever have a Miranda issue, and you don't ever have to worry about going to appeals court and filing motions to exclude statements. So as it stands now, you can file a motion under the exclusionary rule to keep statements out that violate Miranda, but you can't sue for damages for violation of civil rights of Miranda. And this just points out everything I've been saying. I try to pound this into people. I try to pound this into my clients. Don't talk to the police. Nothing good comes from talking to the police when you are the subject of a criminal investigation. I know this from experience. I was a police officer for almost 20 years in Miami. I've interviewed subjects. I've taken Miranda statements. I know exactly how it works. I know how people respond to when the police authority shows up there. A good way to think about it is when you were a kid, if your mother or your father ever accused you of anything, you'd start trying to explain why it wasn't you, why you didn't do it, and you would just dig a bigger hole. In my almost 20 years of law enforcement experience as a police officer and a detective, in the statements I've taken, I have never once seen anybody in that whole time talk themselves out of handcuffs. On the other hand, I have seen plenty of people come into the Homicide Bureau and talk themselves into handcuffs. It's very easy to talk yourself into handcuffs. If an officer wants to speak to you for any reason, or if they've made contact with you, and that contact starts off with, "You have the right to remain silent," or even if it starts off with, "Hey, can I look in your house? Can I look in here? Can I look there?" Immediately demand a lawyer. Affirmatively and expressly demand a lawyer, and do not back down. Keep it up. That's your criminal defense tip of the day, in with a little bit of case analysis. Once again, that's the Koth. It's up here in the corner. If you want the case number, it was released on June 23rd, 2020, right after the Bruen decision was released. If you have any questions about this case or any other, or if you have any issues you would like me to discuss on this channel, please let me know. My email is in the comments, as well as my other contact information. Be careful out there, and never, ever talk to the police.